Good morning. Good morning.
Morning, Blair.
How are you?
Good. Good morning, everybody.
Morning.
Morning,
Start checking in attorneys when you're ready.
Attorney John Harris, checking in on behalf of Devon
What's the last name on your client?
Briscoe, Briscoe.
Oh, Briscoe. Okay, I got you.
Thank you.
Burton Harris, checking in for Del Marco, Cross Kelly.
You're a little low, counselor.
Burton Harris checking in for Del Marco Cross Kelly.
Thanks.
So PCC.
I don't see it, Kelly, on our docket.
It's Cross Kelly. It's hyphenated.
Yeah. I don't see it, counselor. You got a case number?
No, let me. I'll pull it up on the ROA and see if it got changed or something at the last minute. Actually, you know what? I do have a case number. It's 210 563 0003.
It says the PCC is April 14th.
April 14th. Okay. All right. Sorry about that. Thank you.
All right.
Good morning. This is Natalie Phelps. I'm checking in on Lawson, which is an exam this afternoon. But he's planning to zoom in at 10:30 to see if we can put a waiver on the record if the prosecutor does not object to that.
Hold on, counselor. Hold on. And it's got, let me see, Judge, because I'm checking the code.
Hello?
Yeah, you know what? I don't know why they. Hold on. So it's 3 defendants on there. This is the one Mr. Harris is talking about. But defendant number 1.
Have a good day at school, love. I love you.
Your system's on mute, please.
Oh, I'm sorry.
Today's the 17th, right?
Oh, yeah, there you go.
Now, defendant number 1 is saying for today, but I don't see defendant number 1 on our document. Jameer O'Neal. Oh, they removed it. Somebody downstairs removed it. And put it, ours. Yeah, and they put it for the same date, 4/14. 2607.
5.
Yeah, 5/2607. Okay, I'm sorry. I think Natalie, were you saying something?
Yeah, so I was trying to check in on Lawson, which is it's an exam this afternoon. But we are hoping to waive, and the client was gonna zoom in at 10:30 to try to get that done. And then I also have a case I just wanted to bring to your attention that's up for exam on Tuesday. But unfortunately, I've tested positive for the coronavirus, and so I will not be able to come for that, obviously. So I was trying to get that adjourned while I'm here this morning as well.
Can you do it on Zoom?
No,
You said no?
no, the preliminary exam, no, that,
Yeah, the one for Tuesday, can you do it on Zoom?
no, we are demanding an in-person exam for that.
I have your P number?
Yes, it's 83355.
All right, so we need to wait on defense counsel for Lawson and his client. Is that correct?
I'm defense counsel, so the client is planning to Zoom in at 10:30. It's just not scheduled until this afternoon, so I just wanted to give you a heads up that that's what we are going to try to do.
Okay, so you told your client to be on at 10:30?
Correct.
Get them on now?
I'm sorry, I couldn't.
Can you get him on now? Because 10:30 I'll be doing exams, so he's gonna be
Okay,
waiting.
yeah, I'll call him right now.
She did.
Good morning, Madam Clerk. Could I check in with you, please?
Yes, go ahead.
Hi, this is Henry Schneider. I'm checking in on John Williams, who is on Zoom. We're scheduled for a bond hearing.
Okay, I got you. Who's next?
This is Scott Nadeau, attorney for David Tiernan, PCC today, first one.
Okay, I got you.
Thank you.
Who's next? Any other attorney need to check in?
Kitty, I'm the prosecutor on the case. Good morning. Nida Simona for Charles Douglas. I think White Harris is what I have as his attorney, first PCC.
Yes, he hasn't checked in yet.
Okay, I'm here, so thank you.
Your P number?
45356.
Thank you. Any other attorney need to check in?
Madam Clerk, I checked in, but I didn't give you my P number. This is Attorney John Harris. My P number is 43658. Thank you.
Okay, I have it. If I don't ask for it, that means I have it.
Oh, yes, thank you.
Thank
Phelps is back.
Who?
Phelps, I think she might be back on the client.
Yeah, I just spoke with Mr. Lawson and he's signing on right now.
Okay. And what was the client's name on, you said Tuesday?
Yes, that's Jimmy Hayes. I can give you the case number if you like.
I have it. So Blair, this one, defense counsel is scheduled for exam on Tuesday. She wants, an adjournment. She's asking for an adjournment.
Because she has COVID.
Yeah,
I don't know what it is.
huh?
I know it's something that's. Continue on with it.
You want to in person?
But it's in person.
She wants it too.
Yeah, she said she wants to be in person. I asked her if she can do it on Zoom. She said no.
Whatever the court wants to do.
Yep.
I don't know what kind of case is it?
It's a retail fraud, first degree. Just one count. All right. Huh? Yep, you want the ROA?
Yeah, that'd be great.
Can you get on that? All right, we ready?
Yeah.
439, just all right. Okay. Yes, yes, the persons are calling, yes. You have to be here after the scheduled time. Okay.
I'm sorry, this, the ROA doesn't say when it was scheduled for. Was it scheduled for, you said Tuesday?
You said it doesn't say when it's scheduled for?
No. It says probable cause conference held. I'm not seeing it on there. March 11th?
Oh, that's crazy. Yeah, I don't see it either. But it's on the,
On the docket?
yep, it's on the form, it's in the file. I got the file,
So that's what, March
23rd
March 23.
at 1:45. That's odd.
Yeah.
Okay, anyway, we ready? Ready on Devon Briscoe?
I'm ready, Madam Clerk.
Calling case number 2155763, the people of the state of Michigan versus Devon Briscoe. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Your Honors.
Good morning, Your Honor. John Harris on behalf of David, P43658. My client is present on Zoom.
Is he on Zoom?
He is, Your Honor.
Yes, sir.
Briscoe, state your name for the record, please.
Davon Briscoe.
Thank you, sir. Hi, counsel, Mr. President.
Your Honor, we had asked His Honorable Court to set a date for preliminary examination. Also, we'd like to receive discovery from the prosecutor, the video discovery, ensuring that.
I can't hear you. You gotta speak louder, please.
Yes, Your Honor, we'd like to put this for preliminary examination. Also, to request video discovery from the prosecutor, ensuring that the audio is working, please.
So,
All right, yes, for the video discovery.
counsel was sent to you on the 12th of March. Video and paper discovery should all be in your email.
Yeah, we have the paper discovery. We do not have the video discovery.
I can't explain it. You may want to check your spam because it says here successfully sent. I've got a document that indicates that. So maybe it may go into your spam. I don't know. But it was both sent. If you got one, you should have the other.
How many witnesses?
Judge, I have 2. Possibly do with 1.
Your Honor, I didn't hear the last comment. I'm sorry.
Oh, he said he can possibly do one witness, so I'm looking for a spot for you.
Okay, thank you.
Parties available March 25th at 10:45.
Give me 1 second. March 25th works for me, Your Honor.
All right, Bob continues here right then. You're gonna have to make sure you get, follow up about that discovery to make sure you have it so you're ready, counsel.
I will. Thank you, Your Honor. What time is it? I'm sorry, I apologize.
It's at 10:45 and I call them right, I'll call that right at 10:45.
Very good. I'll be
All right.
timing. Thank you, Your Honor. Have a
All
good
right.
day.
Thank you, you too.
Ready on John Williams?
Yes.
Calling case number 1958380, the people of the state of Michigan versus John Williams. Defendant number 2 is charged with count 1, home invasion first degree, count 2, robbery armed, count 3, weapons felony firearm, count 4, weapons felony firearm. This matter is here on a motion, emergency bond motion.
Good morning, Your Honor. NDS Detroit by Henry Schneider, 82476, appearing for Mr. John Williams, who is present on Zoom.
Mr. Williams, state your name for the record, please.
John Williams.
Mr. Williams, you gotta get somewhere I can see you because I can't see you.
All right. Can you see me now?
Yeah, that's better. Thank you.
You welcome.
All right, Snyder.
Yes, Your Honor. Well, first, I'd like to correct a couple things in the bond motion I submitted. I included the year of 2021 in some instances where I meant 2020. Mr. Williams was arraigned in August of 2020 and granted a bond of $10,000 or 10% with the GPS tether. His bond was posted on August 21st, 2020, and at a probable cause conference on August 27th, 2020, Mr. Williams requested a live preliminary examination date, and he was scheduled for a live preliminary examination on January 12th, 2021. Due to COVID closures, that preliminary examination was rescheduled for August 18th, 2021. So that'll be around a year after Mr. Williams posted bond in this case. And since he's posted bond, there haven't been any issues, no tether violations or bond violations alleged. And so I'm asking the court to consider removing his tether, given that the case is taking so much longer than normal, that he hasn't violated in any way. Mr. Williams does not have prior convictions, and he does not have a prior capious history to my knowledge. So based on the length of time that the case is taking, I think it's unfair to keep him on tether for so long. It is inhibiting his ability to search for work, which he's trying to do. And finally, if the court is not willing to consider removing Mr. Williams' tether, I would ask that you allow us to request a video examination in the hopes that it could happen at a sooner date.
The video examination is not gonna happen at a sooner date. It takes longer to do them than in person, so.
Understood.
Yeah, got audio now.
Do the people wish to be heard?
Yes, Judge. These are serious charges. It's reported that Mr. Williams, along with the co-defendant, entered the victim's home through an upstairs bedroom window, There was a gun used. The victim was held at gunpoint. It's reported that there was money taken from the victim, and the keys were taken. Apparently his keys, I don't know if they were in the house, car, what have you, but his keys were taken at the time. Apparently the victims and the defendants knew each other for a long while. We think, Judge, at this point in time, given these charges, that Heather is certainly reasonable. I don't know of any component of the bond rule that indicates that because the case is taking too long, he's out. He's free, he's able to do what he needs to do, except for his limitations on the tether. And those are reasonable. Now, if he's time to go or a way to get to work, the court can accommodate.
What you want me to do now?
But just sit.
Huh?
But just sit. That's all we about. Go ahead.
Okay. People feel that an accommodation can be made for a short period of time, which he can go look for work only doing that, without being able to go to near the complainant's victim's home. With that, Judge, given these serious charges of robbery, armed, home invasion first, the tether is certainly reasonable.
Any brief rebuttal?
Your Honor, yes, just briefly, I will note that the facts of this case are set in December of 2018. So it is a fairly old case. And second, the complaining witness described one of the perpetrators as being named Jonathan, aged 17 years old. Mr. Williams is 23 years old now, and at the time of the alleged offense would have been 20 years old. So I expect there may be some identification issues in this case, but we'll ask you to consider removing Mr. Williams' tether.
All right. After hearing arguments at this point, I'm not removing the tether. The bond's gonna remain the same. Anything else?
Just, Your Honor, I know sometimes preliminary examinations that have been previously scheduled are waived, and I would ask the court if a sooner preliminary examination date is possible at all.
It's crazy, dude.
Two witnesses.
should the first co-defendant have a date set or anything done with the first co-defendant?
I have no idea. I'm not showing.
Oh, you're not?
Gotcha.
You got it here. Number.
Terrible.
It's the same number. Terrell.
Yeah. Is he still?
He waited.
Oh, he waited up? Okay.
Well, it was hell no.
Okay. Didn't know that was still outstanding.
That was back in July 9th, 2019.
Okay. July was that?
When it was found over?
Yeah.
Yeah, July 18, 2019.
Okay, thanks.
All right, move it up to May 10th at 12:30.
I'm sorry, Your Honor, did you say May 10th at 12:30?
Yeah.
I apologize. I'm scheduled to be out of that office that date for a medical procedures. Is there anything available that week instead?
Nope. Oh. Well. May 17th at 12:30.
That'll work just fine, Your Honor. Thank you.
5/17, 12:30, yeah.
Is Tyron yours, Blair?
Who?
David Tyron?
Here? No, that, you know what? I have that down as an attorney general file.
I am here.
And so am I. The attorney.
Right, your defense attorney. Is the prosecutor on? No, you have a special prosecutor. I gotta recall it when I get the prosecutor.
Okay, do we know who that prosecutor is? I could attempt to contact that person myself.
You don't know, do you, Moody?
I don't, I checked the ROA.
On the warrant, it says Daniel Gutterson.
Oh, yeah, that's the name I checked, yeah. I think he's with the AG.
Yeah.
All right.
Did you get it, counselor?
I did not. Is Daniel, what was the last name again?
Daniel Gutterson, Gunderson.
Okay, I'll try to contact that person. Please note, I have another Zoom call in Isabella County at 9:30 for court. So hopefully we can get him in before that. I'll try to contact him. Thank you.
Okay.
Right.
Thank you. Mr. White Harris is not on, right, Judge?
Nope.
Okay. Ready on Lawson?
Yes.
Decrease Lawson. Calling case number 20-57054, the people of the state of Michigan versus Jaquise Lawson. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. Officer Blair, will you-
Good morning, Your Honor. Neighborhood Defender Service by Natalie Phelps, P number 83355, carried on by Mr. Lawson, who is also present via Zoom. Mr. Lawson, can you please state your name for the record?
Jaquise Lawson.
Thank you. Your Honor, we're scheduled today for a preliminary examination. I've discussed with Mr. Lawson his right to a preliminary examination. He does wish to waive that right.
Any objection?
No, Your Honor, thank you.
All right, Mr. Lawson, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause that you had something to do with committing that crime. You understand that, sir?
Yes.
Has anyone promised you anything or threatened you in any way to get you to waive your right to preliminary exam?
No.
You do so freely and voluntarily after having opportunity to talk to your attorney about it.
Can you repeat that one more time, sir?
You waive your exam freely and voluntarily after having opportunity to talk to your attorney about it.
Yes.
Do you have any objection to the court signing your name to the waiver form and initialing off?
No.
Counsel, do you have any objection to the court signing your name to the waiver form and initialing off?
No.
No, sir.
And no, I'll start with counsel. And Mr. Phelps, are you wearing a shirt up under that jacket?
Oh, yes, she checked in.
I'm sorry, I didn't hear that last part.
Are you wearing a shirt with a collar up under that jacket?
Yes.
I'm asking your client.
Oh, sorry. Yes.
Oh, no.
This doesn't have a collar on
T-shirt on?
it?
Yes, I have a t-shirt on.
I don't do t-shirts.
Oh, I'm sorry, sir. I'm actually at work right now, so I was.
I don't care where you're at. Right now, you're in my courtroom.
Oh, okay. I'm sorry, sir. I
That's great.
apologize.
Well, Mr. Lawson, I appreciate your apology, but I don't want it. I want your respect.
Understandable.
You understand something, Mr. Lawson? Normally, I'd bring you back in here and send you Wayne County Jail and let them dress you. If you don't know how to dress right. You understand that?
Yes, sir.
When you come to court, you dress for court, sir. Give the court its respect. You want the court to respect you, right?
Yes, sir.
I want the same thing.
I absolutely understand.
All right. Did I ask you, did you have any objection?
I think you did, but we do not. Thank
All
you.
right. All right, call to find that you freely and voluntarily waive your right to preliminary exam as bound over the Wayne County Circuit Court Criminal Division arraignment on the information, which will be March 31st, 2021 at 9:00 a.m. And bonds continue.
Thank you, Your Honor.
All right, thank you.
So Austin, you're all set to hang up.
Okay, thank you. Have a good day.
March 31st. Okay.
Good morning, Your Honor. This is Attorney Elizabeth Young. I have a client who's in the hospital right now. He wanted to walk in on a failure to appear. So it's not on the court's docket, but I did want to check in on that matter.
Is your client on?
He is. I see he's in a wheelchair right now being rolled by a nurse. Galaxy J7.
What's his name? I need a case number.
I need a case number, counselor.
The case number is 200-5742-601.
Okay, we ready on Jimmy Hayes? Did she leave?
Who's that?
The attorney
No.
Natalie Phil.
She's still on it. Ms. Phelps? Ms. Phelps? All right, go on, something else.
Counselor, are you checking in? In the car, are you checking
yes.
in?
Yes, ma'am. Richmond Riggs, P33863, Assistant Attorney General on the matter of People versus David Tiernan.
Oh, okay. I don't know where the attorney went. Is he still on?
I'm right here. I'm right here.
Okay. Calling case number 1861589, the people of the state of Michigan versus David Tiernan. Defendant is charged with count 1, larceny in a building. This matter is scheduled for a probable cause conference.
Go ahead.
Good morning, Judge. May it please the court, Richmond M. Riggs, P33863, Assistant Attorney General on behalf of the people of the state of Michigan.
Hey, good morning, Your Honor. Scott D. Nadeau, P64316, on behalf of Mr. Tiernan. Mr. Tiernan, could you state your name for the record, please?
David Christopher Tiernan.
Thank you. Your Honor, today's the first PCC. I still have not received discovery. We would just ask for an additional date for me to review with my client. It is an older case, and hopefully we can get this resolved. I can't make a decision about the exam without having discovery and going over that with my client.
Oh, okay, well, I'll make it then. I don't adjourn the PCC.
Okay.
I'll set up a preliminary exam. You're gonna have more than enough time to get discovery and do everything you need to do. If you decide you're not gonna hold it, just contact the court and we'll move the date up, okay?
Not a problem, Judge.
All right, thank you.
Mr. Nadeau.
How many witnesses?
2 witnesses, Judge.
None for me. Mr. Riggs, I'll give you my phone number at the end of this hearing. We can talk.
Very good. All right.
Party is available May 24th at 12:30.
Yeah, I am.
12:30, Judge?
Yes, sir.
Yes, sir.
All right. All right, anything else?
Nothing, Your Honor. If I may, I'm just going to give my phone number to Mr. Riggs. Mr. Riggs is
Sure.
313-737-0050.
313-737-0050.
Yes, and I'm available to talk for a couple minutes right now, if you like.
Okay.
Thank you. Thank you, Judge. I'm going to sign off now. Mr. Tiemann, we'll talk later.
All right, thank you.
Thank you, Judge.
Thank you, take care.
Any other attorney need to check in? Oh, there's Natalie. Mr. Tuttles, who are you on?
You're on mute.
Good morning. I apologize for being on mute. I want to monitor a situation that attorney,
Still can't hear you. Too loud. You gotta turn it up.
okay. I want to monitor a situation where attorney.
We still can't hear you, Mr. Tuttles. It's too low.
Okay, I'm not. Okay, I'm sure why. I'll call on another device.
Okay.
Okay. Ready on Jimmy Hayes?
Yes.
Calling case number 21-55628, the people of the state of Michigan versus Jimmy Hayes Jr. Defendant is charged with count 1, retail fraud, first degree, habitual offender, fourth notice. This matter is here on an adjournment hearing.
Good morning.
For next Tuesday.
Good morning, Your Honor. Neighborhood Defender Service by Natalie Phelps, P number 83355. Appearing on behalf of Mr. Jimmy Hayes, and I would waive his appearance for the matter, for the purposes of this hearing this morning.
Waive his appearance for the purpose of this hearing. What's your pleasure?
I'm sorry, Your Honor. I'm requesting an adjournment of the preliminary exam. We have an in-person preliminary exam scheduled for next Tuesday. That is March the 23rd at 1:45 p.m. Unfortunately, I have been diagnosed with COVID-19 and will be in isolation until the end of next week. So we are requesting an adjournment, a new date for an in-person preliminary examination on this matter.
Any reason you can't be on Zoom?
Your Honor, I would object to holding the preliminary exam via Zoom. I would need to be in person.
I'm not saying I'm holding the exam by Zoom. I'm saying you being on Zoom.
Right, but I would need to be able to be with my client in person in order to properly defend him, to provide adequate defense in this case.
People got anything?
Judge, we leave it at the court's wisdom. Yeah, the defendant's right.
Well, the defendant's right to be in person, it's not the attorney's right to be in person. It's a difference. April 5th at 9:15.
Thank you, Your Honor.
What time was it, Judge?
9:15, April 5th. All right, anything else?
Your Honor, I noticed on the ROA, it looks like my P number was just entered with one incorrect digit and it had a different attorney listed. I just wanted to make sure that was corrected for the ROA as well.
Yep, I corrected it.
Okay, great. Thank you so much.
You're welcome.
Your Honor, can you hear me now? This is Tuttles.
Yes, you're hearing Mr. Tuttles. What do you have?
I don't have anything. I'm here to monitor a exam. Clement, Adam Clement's supposed to be the a lawyer on.
Oh, that's Ayers?
That might be the name. That's a co-defendant in a three defendant matter. Do you know about what time that's going to start?
It says 1:30.
Oh, okay, that's this afternoon.
Yeah.
Okay, I'll chime back in then.
That's a special prosecutor.
Mr. Tuttles, that's a kidnapping, false imprisonment?
Yes.
Okay, yep, 1:30.
Okay, I'll chime back in. Thank you.
Okay, you're welcome.
Kitty, I don't know who's on there. It's a special prosecutor.
I mean, you didn't want the prosecutor's name.
Pardon me?
You didn't want the prosecutor's name, did you?
No, I just want to let you guys know it's not me.
Oh, yeah, figured. Anyone else need to check in? Oh, I got that sheet.
Good morning. This is Robert Hayes from the Attorney General's office. I'm filling in on Tiernan, I believe.
Oh, the Attorney General, I guess is on it. He called in. We already scheduled that one. We did it.
Perfect. Thank you.
All right, thank you.
Thank you. So is, what was the attorney for that warrant? Is she still on?
Yeah, that's Elizabeth Young.
Oh, yeah. Ready, Ms. Young?
I'm ready.
Calling case number 2057426, the people of the state of Michigan versus Charles Thomas. Defendant is charged with count 1, largely in a building. This matter is here on a warrant hearing.
Good morning, Your Honor. Neighborhood Defender Service by Elizabeth Young appearing on behalf of Charles Thomas. Mr. Thomas is out of custody. He's appearing on Zoom right now. Mr. Thomas, can you unmute your microphone? Look in the lower left-hand corner, hit the microphone.
All right.
Well, now we can hear you. If you're able to turn your video back on, that would be good.
Huh?
We can hear you now. Can you turn your video on? Your Honor, his video is on now, but he's back on mute, so.
Go ahead, Counsel.
Okay, Your Honor, I am respectfully asking that the court set aside the bench warrant. Mr. Thomas was supposed to be in court on the 10th of March. He was hospitalized at that time. I did send proof of the hospitalization to the court. I would be happy to resend it right now.
You sent it to who?
I sent it to your clerk, Your Honor.
No.
No, she
I
doesn't
was
have any.
sent it on the 12th. I'm going to re-forward it right now. I just sent it. And Your Honor, I would just add that Mr. Thomas did call me that afternoon immediately after he was released from the hospital. And I told him that he needed to walk himself in. We have been talking about how Zoom technology works, and he's finally figured it out, but it's taken some time. So I assure the court today is the soonest we were able to do this.
That's what she said.
Okay, this doesn't have anything on it. It says hospital stay details.
You can see that there's a date in the lower right-hand corner that says 3/10, and at the top it also says 3/10. And that he was in the hospital for 8 to, I'm sorry, Judge?
Hold on. You want to see this?
Yes, please. May I approach?
Yes.
I'm doing well, thank you. Pardon me? Absolutely. Yes, it is. No, because this person is nobody to always open.
Anything you want to add, Mr. Moody?
Just, Judge, it presumes that that was a screenshot taken from some computer, I don't know what it was. I would leave that up to the court's wisdom. With regard to this matter, what is the underlying charge, Judge? Do we know?
The underlying charge is larceny in the building.
Does he have any other positions on file, tether, anything like that?
No. It doesn't look like it.
Just like a no contact reason?
1 second. I was told there's a no contact provision. It's not in the ROA.
Is it arson first, Judge?
No, larceny in the building.
Oh, larceny in the building, I'm sorry. Okay, all right. We will leave it up to the court's wisdom, Judge.
All right.
I did have a look at the form.
All right, I'm gonna reinstate, well, I'll set aside the habeas and reinstate the original bond. You can make sure your client
Thank you,
understands that this is his next date. I won't do that again.
Understood, Judge.
Is that with a no contact provision?
Yeah, that includes a no contact provision. Okay.
Let me get a chance to get the Not right now, I've got it at 9:30.
All right, May 14th at 12:30.
Your Honor, I do have 2 preliminary examinations already scheduled for that day. However, they're both in 36 District Court, so it will likely work.
I'm gonna call it at 12:30. I don't go by likely.
I can't guarantee that my second exam that morning won't go longer.
May 21st at 12:15.
That works for the defense. Thank you very much, Judge.
I'm sorry, May 21, Judge?
Yep.
Or 12:15?
12:15.
Okay, thank you, Your Honor.
You're welcome.
Mr. Thomas, you can sign off.
Your Honor, Kitty, can I trouble you? This is APA Simone on Charles Douglas. Could the court possibly call Mr. Harris to see maybe he wasn't aware that it was up today, the PCC?
Who's Mr. Harris?
Wyatt Harris. The attorney on Charles Douglas.
You got his number?
Yeah.
Yeah, we'll give him a call.
Thank you.
Oh, there he is.
I'm sorry, I didn't have it noted.
I just had a text you. Okay, very good.
Thank you, Ms. Simone.
Thank you.
All right. Okay, thanks.
Ready on Charles Douglas?
Yes.
Calling case number 2155954, the people of the state of Michigan versus Charles Douglas. Defendant is charged with count 1, criminal sexual conduct, 4th degree, count 2, criminal sexual conduct, 4th degree, habitual offender, 4th notice. This matter is scheduled for a probable cause conference.
Good morning, Judge. For the record, Nida Simona, Assistant Prosecutor for the people, P45356.
Good morning, Your Honor. Wyatt Harris, P54891 on behalf of Charles Douglas. Is that Douglas? And I see you got Chuck's Galaxy. Is that you, Douglas? Okay.
Yes.
Your Honor, we'd ask for preliminary exam date. I don't believe I have discovery.
All right. Mr. Douglas, state your name, please, for the record first.
Charles Jerome Douglas.
Thank you, sir.
You're welcome.
All right. How many witnesses on this?
One witness, Judge.
You should have, I don't know, is it in the file?
Nope.
Parties available May 25th at 12:15.
Defense is available, Your Honor.
We're ready. We'll be available, Judge. Thank you. Harris, I'll make sure to send you all the discovery.
Thank you very much. Your Honor, can you place myself in Mr. breakout room briefly?
Yes. All right, I'll continue.
Thank you, Your Honor.
Thank you. Have a good day, everybody.
You too.
Sharon, here.
Yes, yeah, they coming in now. Yeah. Blair wanted to talk. Sure.
Up there.
You got an attorney?
Yes.
Well, come on in, it's late already. Oh, no, it's not 9:30.
Mr. Moody called him and started talking to him. I was trying to pull him in, and Moody, Blair is talking to the attorney.
Oh,
Yeah, I think it's gonna be a plea or something, plea offer.
please.
Attorney needs to talk. Yeah.
Okay.
Please go there.
Burrell? No.
Attorney?
Sorry. Calling case number 2058175, the people of the state of Michigan versus Premier Chandler. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. May it please this honorable court, Joseph Walecki, representing Mr. Chandler. He's present in the court.
Chandler, state your name for the record.
Chandler.
Chandler, you don't know how to address the court?
I apologize.
I don't want your apology, sir. I want your respect, and I'm not getting it. I don't do sweats, and I don't do t-shirts in my courtroom. My question is, do you know how to dress for court? And why didn't you?
I'm prepared.
Oh, I'll prepare you. I'll just send you Wayne County Jail. We do this on another day. That's how that works. We'll dress you over there. One of those days can come back. Well, I gotta give him a thing. You need to know how long he's gonna be sitting over there.
Okay.
Judge, I would plead to the court to give us an opportunity to have at least exam for this judge. I understand.
The client is not prepared. He's not ready.
I'm not even sure the prosecution.
But your client is not. Your client is not ready, you don't do nothing. You know, I don't know how, I ain't got nothing to do with other courtrooms and how other people handle their courtrooms, but I have to do with how I handle mine. And I've done the same thing over 15 years I've been sitting on this bench. I don't do t-shirts. I don't do sweats, counsel, period. It's disrespectful. And to have a nonchalant attitude about it is even more disrespectful.
I'm available on the 25th, John.
25th, you think I'm back tomorrow morning? You want to leave them in there till the 25th?
Magistrate. I could do Friday morning, Judge. As long as I'm a magistrate in the afternoon, Judge, but I could do Friday morning.
Now let's go stand there. Chandler, when you come to court, you dress for court. Do you understand that? What are we doing? That's what we're holding.
We're ready to hold, we were prepared to have it. I'm not sure if the people are prepared, you have to check the process.
Judge, I did go in the hallway. I do not have my officers. I do know that I have one officer who is apparently. Who is out with COVID. I got this email on the 16th, that was yesterday, from the officer in charge. That was one of the witnesses, essentially witnesses, and another who is on furlough, employees there too. The officer in charge indicated that she would be here, but she was not going to report further. So at this point, we're not able to go forward.
All right, matters dismissed without prejudice.
Thank you, Judge.
Now that they can, hold on, they can refile it. You understand this? They may refile it, I don't know. But if they do, you have to come back to court, address the court, all right?
Thank you, Judge.
All right, I need a dismissal form.
I appreciate it, Judge. I apologize for not having my client better prepared. Thank you.
Well,
You're welcome.
Case number.
What's your pay number, counselor?
43103.
Yeah.
May I approach them?
Oh, wow, I told I was gonna be before you.
I don't think you've ever met my judge when you're going to this will happen. Tell me, Paul.
No.
I didn't think so. He said, it's never been before you guys go out.
Yeah.
Literally.
Literally.
Thank you, Judge.
Oh, boy. You all right over there?
Yeah. I guess I'm getting soft.
Oh, you did. Yeah, you sure would. You see, you know, you're not a beast anymore.
Thank you.
All right. Yeah, that's. So. Take care, Joe. Thank you, man.
Excuse me, I apologize, but, officer here.
Okay, thanks.
Oh,
He said, I heard him. Just the way he said it, you just. I
oh,
was cracking up and said, so, he got his.
oh, the planet?
Yeah.
Oh.
Big baby, man. I said, he just. Yeah, it's good to turn that away from God. Yeah, right. But you know, that's what's happening. You're trying to think.
Yeah.
They all,
Everybody thinks that, oh, I gotta carry it out.
because I got to protect me. And, you know, it's just sad. It's sad. I mean, I don't think a lot of want to, but they kind of like trying to, you know, represent or something. I don't know. Everybody's got this like we, you know, it's these right here. These are, you know, we don't do that. And like I say, you can take it back, but you can't change it. But they have to understand that's not. It's always ways to get things done. Walk away from it, because it's the attitude. So walk away. I mean, just like if you kept turning with a guy you was going to like, if you could beat him, if you could, you know. But this will keep you there because you think, oh, I can't find y'all. He does. Time.
Yeah, I'm definitely. You go talk to him.
Oh, no.
Yeah, right. Started yesterday.
He's trying to do that. I don't know if something was wrong with that. Did that earlier this week? Or last week?
Miss Margaret?
Yeah, Mike Riggs didn't show up until.
It was one of them. I don't know if it was last week, but sometime, one time in this courtroom, she did, right. It kind of late. I saw her yesterday. She was from Kansas. I know she was up here on this report. You don't play night.
You don't have your keys.
You don't play night. I can go to my car. In my car.
I ain't got my bag. In my other car.
I knew something that fell out my.
A defendant was on Zoom over there. Tells King I want to represent myself. Tells King.
Oh. Oh, that's right. Did you go over it? Did you do it? Right.
Next door.
So, did you do it, Donna?
I was wondering what you got his document on.
Okay. Thank you. Her case got moved, Judge. I'm sorry.
Huh?
She called me yesterday. I forgot. This Kate Montgomery. Burrell went to Judge Jones because Burrell had another case.
Oh.
Wake up, Kitty. Wake up.
I know. I forgot.
I'm able to represent myself. So King said, are you an attorney? Is my question. I need you to listen to me. He never answered the question. He said, that's a yes or no answer. He didn't ask us. I tell you what, do you know what he being held in contempt is? I'm fully aware of what that is. He said, what you think? You know what? I need to be here in court. I need to be here in court on Friday for PCC, guys. We're holding a PCC right now. He said, but I'm a jury. Why did he say? So you using your, where do you derive from using your authority? He said, I'm done with this. I'll see you on Friday. I said, oh, Lord.
You'll see on Friday.
Hey, what you call them, jailhouse lawyers, if you think it ain't no, hear someone say something, oh, you can
They've
say
been in
this.
the law library so long. They only know some stuff, not
I've
everything.
never seen one that could. So.
Not one.
Oh, we had one in, Judge.
So did you hear me on Burrell?
No.
Burrell went to 234.
Oh,
For a PCC today?
Yeah, because
Oh.
he had another case with Judge Jones.
Okay, can I go run that file down to the APA?
Yeah.
We got a 10 o'clock. So.
We,
Judge Jones?
Yes.
it was, Wagner's funeral. Guy
Are
wanted,
you gonna take it down?
he's some
Oh,
kind of
thank you.
Muslim or something, and he wanted to like, you know, represent himself, right? He had his woman in the court, he was trying to showboat. And I stood up, I was standing, I got a little closer, you know, just got a little closer. Oh, you sending your man, you think you sending him over to get me? I was like, dude, I'm just standing here. You know, they always think they can. Didn't take a class of law.
Yeah.
He was in prison, he probably read the stuff and knew some things. He was talking about some other things that I can do something. You know, that something that they learned, they can.
I think they learned.
They right.
They sit up there and they may try to do some research and they'll find one case and like, because you found a case from 30 years ago, doesn't mean it's applicable now.
Right, that's true too. Yeah.
Kitty, can I get the waiver form for Harrison right quick? It's supposed to go for
I can go ahead, you go write that down, I guess.
Well, he wants to do this very quick, so.
10 o'clock, Judge. Well, Mr. Barney's here. His client wants to waive. And then I'll run down and drop this off.
Okay. Sir, stand in the front row now. Mr. Barney, come up here.
Officer Man, approach with the, yeah, okay. Thank you.
Ready on Patrick Harrison? Calling case number 2058293, the people of the state of Michigan versus Patrick Harrison. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Good morning, Your Honor. May it please this honorable court, Jerome Barney, P. 28321, representing Mr. Patrick Lewis Harrison, who's standing to my left, Your Honor.
Harrison, can you state your name for the record, please?
Patrick Harrison.
Thank you. All right. Oh, yeah, but you gotta do the 6 people. All right, this is a waiver?
Yes, Your Honor.
All right. People have any objection?
No, we do not, Your Honor. Thank you.
All right, Mr. Harrison, you understand that you have a statutory right to a preliminary exam when the state must show by probable cause the crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes.
Has anybody promised you anything or threatened you in any way to get you to waive your right to preliminary exam?
No.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it. And you signed the waiver of examination form, sir?
Yes, that's fine.
All right, court will find that you freely and voluntarily waive your right to preliminary exam as filed over the Wayne County Circuit Court Criminal Division for arraignment on the information. Be March 31st, 21 at 9 o'clock p.m. I'll continue.
That concludes this matter, Your Honor?
Yes, it does. Thank you, sir. Thank you.
Thank you.
Oh, okay. What? Your
Judge,
office
did
here,
we
she's on,
did David Tieran today, right?
Yeah, we did that one.
On which one?
Did he,
On the
say anything about his client leaving?
Leaving where?
Permission to leave the state?
No.
So there's a order to sign. He's supposed to be going on a trip with his fiance April 12th.
Prosecutor has the right to object. That was the one with the.
Yep.
Okay.
Moody, do you have Richmond Riggs? Richmond Riggs, the prosecutor that was on today, the special prosecutor for the AG office, do you have his phone number?
I don't. Was it Gunderson? Gunderson or something? Is it?
No, it wasn't the one that was on the warrant, it's actually, Richmond Riggs.
Oh, no. Riggs?
Yeah.
I don't think I have it. Let me see.
439, Judge Johnson. Hey, Crystal. Yeah.
No, I don't have it.
You said what? She don't want it? Oh, okay. There's I see, I'll let Judge, Giles, I think she already took the file.
Okay.
All right.
Yeah, just wait.
Okay.
Take care.
What's that?
I say take care. Tell them, man, Greer, if you want to be signed off, come on.
Okay. Okay. I'm going.
Judge, it's always. So the Burrell file,
Okay.
he has an older case, like I said, so I sent this one down to Judge Jones. We already did it. I just had the file sent down and it's stamped pre-exam, so she don't want it.
You might want to hear
That's all the file.
I mean, you don't want
What
it.
difference does it make?
Doesn't matter where you want it.
How it works, because.
Is it because
it's
it's-
Gray, and then Gray can take it to it.
You don't want it?
Right, that's the exit.
I don't want that thing either. Do you still want me to run it down?
No, just leave it here.
No, my file. I'm not sure.
Yeah, you think your file out there going down.
Okay, that's all I want to know.
That's why I stopped, just in
Hey,
case.
we don't want it more than they don't want it, so.
Best practice, she's sitting up here, I never said, I don't want it. Come on.
You forgot that check that box off, Judge.
That way we're not. All right. Just.
I hear it all now. That's correct. That's why.
Right, then we should say we don't want her cases. I
Right.
mean, that's not
I
how it
don't want
goes.
it. I ain't taking it.
The only reason we can't do DV is because the prosecutor. I mean, come on.
And that was a DB case too? Oh, yeah, she got it.
Well, I don't
No,
even
it
know if
wasn't
her
DV.
case is a DV case. Let me check the other case of for real. She just don't want it because it's stamped
For
pre-hearing.
so pre-hearing, she can't take it or something? Or?
Word.
No, we do the pre-hearing
Yeah.
normally. But if she got a prior, if she has another case, prior case, or older case, then she gets it.
Your girl, that's right. Okay,
Yeah.
that's what I thought. Okay. Well, that's all right. You don't have a game tonight, right? No?
Huh?
You don't have a game tonight. It's tomorrow.
No. Tomorrow.
Yeah, so you get a little reprieve here. Yeah, I hear it. Well, the next case is at 10:30. No one showed up yet.
Nope. The other case is not.
The big fella? Yeah.
DV case.
That's why I said baby Huey, he's a little, I started hugging. I started to give him a hug, you know, when it's COVID. You know, can't get The judge had them all crying. They started to think about going back there.
He was crying?
Yeah, he's tearing up.
Oh.
I was like, giving some tissue, man. I was like, oh.
Oh, shit.
And then when his attorney said, gave the date, oh God, it was really like, they gotta be in there for 1 week.
Right. And the judge was like, you really want him to sit there to the 25th?
He said 25th, I couldn't believe it. Really?
Right, he should have been like, okay, Judge, tomorrow.
Yeah, right. I'm glad I know. We got no trouble. I see what's happening. Oh, boy. Whew.
He won't forget that lesson.
No, he won't. He won't. He was like, oh. I had to tell him, relax. I said, relax, man. You on this side now. You ain't over there, so you can relax. But you're right. I love it when they really feel, know that, you know, it was about to go down. And, you know, it's too bad that some of these churches, I know they're supposed to know themselves, but a lot of times, don't want to teach them anything. But attorney, if you got an attorney, say, make sure you get kids. You know, Judge Giles don't play anything, like you said. Other judges might not say anything.
Mr. Barney flag.
Yeah, oh, you saw it. He was a judge.
Yeah. They schedule homicides 30 minutes apart.
Oh, I need to go over there.
Judge.
Is Judge King on the bench?
He is.
I want me a smoothie.
Oh, yeah. From Judge King.
His son makes them.
I'm coming deer now.
In the court?
No, he bring them frozen, and he bring them every day. And it melts throughout the day. They're really nice, really thick. It's no sugar. It's nice.
So it can really work on you.
It's good for cleansing. And it's better than tropical smoothies.
Oh, they're kind of sweet.
They overrated.
They're very, yeah, it's a lot of sugar. That's why you do look like you lost a lot of weight there.
You know what? My pants don't say so. My belt show don't say so. The holes in the belt don't say so. Matter of fact, we need some new pants. We need some Corona.
We do need some new ones.
We need some Corona pants with the elastic on the back.
Because we all get them.
I'm gonna do like my grandma used to do. She used to slit. She gonna know that they used to slit the seams and put some elastic on.
They can't do that, do they? Sure
my grandma used to if she didn't do that, they would take a rubber band and unzip it a little bit.
Yeah. But you know, hey, I tell you, it's just, I won't do that because I'll force myself to work out. If you do that, then you start getting confident before you know it, you're gonna do it.
Fat and I'm pasting on.
I had suits. I gotta find out if my suits fit anymore.
You know what? Yesterday I had almost 8,000 steps.
I gotta go back. There's too much going on over there.
Yeah, they docked.
Oh my God.
That docked is a lot today. They got 2 homicides 30 minutes apart.
There's one lady on Zoom, they're trying to do a plea and she's, I guess, in the daycare and she's walking all around, but you can hear all the kids.
Oh God.
Like, oh my God, sit down somewhere.
Have someone else take care of that. You go in the office and zoom in.
Or outside.
Yeah, the judge had to find
Or in your car, right.
Neglect.
Right. You said you can't do.
Who was that there that said, be still?
Judge
Archie.
No.
It was Archie.
No, it was Archie. So who do we still?
You told the officer to be still.
That was
told Lou.
Lou, that was Judge, the head judge, chief judge. What Calico told.
Yeah.
Officer, girls are trying to keep guys, take your jacket. I'm trying to keep everything right. Judge Douglas, did I say, I want you to stop moving, give me that or something, say something like that. Stop moving, I'm trying to do this. So I tell people, don't do too much, man, just relax. He'll tell her.
Judge, on this, is this 12:15? I'm assuming it's 12:15.
But you know what?
Yeah.
But, you know, in Lewis' defense, Gross's defense is that you work at circuit court. That's what they expected us to do, to keep things right and move, you know. And they did that, it was up there, everything down here, y'all make sure you're right, because I had to go talk to them, and they backed you. Then officer such and such told you to do this, that.
They got it.
Mm-hmm. Right. Oh. Yeah, you tight. Yeah, I got up, I had to stretch a little, I do that little, I did my little pre-thing before I go and take my shower, stretch and try to get loose. Put a little heat on that, you know, so I can, you know, loosen up. And then when I get into shower, a hot shower, man, I loosen you up good.
That boy was out there just crying.
It's just,
He almost made me cry.
she was still crying out there.
That's the same boy?
But he went out there to the crowd. Oh, Lord, he almost made me cry.
Judge, you must have won.
I wasn't very disrespectful. I just don't have oh, Lord. I'm getting sensitive in my old age.
No, I just want to tell you, say he didn't really.
Well, I don't go back, I wouldn't like, I look at the file. Normally, if I look at the file, if I've had them before, and there's an issue, I told them, I put my little notes in the file. So I looked in the file to see if there was anything in there. I said, well, they probably did. But this is the first time, but I gotta let them know.
Yeah.
You know.
Oh, he said, oh, I learned from the day I won't go nowhere else. I said, well, I take care of my business. And I said, yeah, because I told him, when I saw him, I said, let me tell you something. I feel like I'm here to be a mom sometimes. Let me tell you something. Anytime you go take care of your business, go dressed appropriately because you don't know how you're going to be judged just by your appearance.
Yeah. You would do judge.
He was out there shaking, crying. I was like, oh, I was look crying. Put my hand on the calm down for me. You could see him when he was right here. He could start breathing hard, sweating. Well, that other one said, man, I ain't had no money, but I went to Kohl's.
Someone give me a shirt.
He said what?
The one after him, he had told him, man, it's gonna be all right. He said, but I ain't had no money, but I went to Kohl's. He said, I just got this whole hookup. I ain't on nothing.
Oh, the one, he had a shirt tie.
Mr. Barney's.
He had a shirt with the tie, the whole package.
Yeah, that's how they do it. That's a smart thing to do.
Mr. Barney let him know. Shoot, he been before Judge Giles.
I think every attorney should let them know.
They should.
They should. I think they should.
I tell all my clients how to dress, what they say, how to talk.
What not to say.
What not to say, especially, I say, well, if I, you deny, you keep your mouth shut.
Yeah.
You know.
You do the talking, huh?
Sometimes they, like that one last Friday, I was kind of hoping he's gonna talk himself in the truck.
Man, that's the one, yeah, the guy was in Jackson.
All them charges and then they don't even show up.
They're scared.
He's got imprisonment
They were scared.
as
That's what.
well.
Yeah.
And they go out on the street and do something else worse. Because one that before didn't show up.
Someone's gonna kill him.
Oh, that's, yeah, right. Because you meet his match, you meet the right person, they get with him. I thought it was gonna be me.
He told me, you need to mind your business. I don't need your consultation.
I called him before he came.
Probably the advice wasn't working then, huh?
Yeah, right. I don't need no mama. Get away from me.
Hey, but I can say this right now. You kept saying, well, I could talk about you all day. in these folks. Yeah, but we can see. I said, why my dad? Not even your president.
Judge Giles is very forward, that.
Yeah. I think he might be ready too.
Yeah. Oh, definitely. That's funny. Oh, I got that store. I can get you one. That's what I said. Yeah, that's perfect. Detroit. 36. I'm trying to get in touch with a young man who does shirts and all that. I know he has his own business. I got to figure out where it's at. So I'm waiting my way home. So I was gonna see if we can hook up a couple with the Emblem 36, and I was gonna get you one. Yeah.
Yeah, some of the guy was doing the math, and then we went, they charged like, that's what was the first time doing them. We charged like $30.
I know, they're getting crazy. Oh, yeah, some places would do that. Yeah.
That's crazy.
Well, he was hand painting them and stuff, so.
Oh.
Put a little more work into it, but.
Yeah. Well, that, a friend of mine's son, he's always been a kind of entrepreneurish. He was reconditioning for gym shoes for him.
Really?
Yeah.
Oh,
And
wow.
hand paint them and all that other stuff.
Especially you can get some nice Jordans, man. You want that, new Jordans, old Jordans, it costs.
Yeah.
That's kind of cool. If I had some old Jordans, I would love to have them reconditioned. Cause I ain't spent 200 for gym shoes. Especially I don't wear them enough. I do it for work shoes because.
Well, go far, and your client is here and there holding their client.
Go far.
I'll be right back.
All right. Yeah, it is.
It is.
It is.
It is.
Yes.
This is one that,
Yeah.
See, I always thought you was cool.
you shouldn't know.
You mean Thursday?
You should know.
He's hardcore.
Did you go? Okay, hold on. Okay.
You know something?
It's
You know, I
scheduled for
realized
Friday.
Blair Moon is pretty cool. When his cousin came up in here.
Yeah, he's a good guy. He's cool, wasn't he? The only thing he did is that he did something.
Yeah, right.
What's up? Hello, sir. Good.
Yeah,
Hello, good.
both of you.
How are you?
Great.
Yeah.
Yes, we already have on it. It's scheduled for this Friday. Okay, I'll close the file. Okay, I'll close the file.
That's right. Well, for certain ones, but if the judge will push you, go to the doctor.
No, the judge.
I know, I said it's not.
All right.
Here's the diversion, I can't do it at a certain age. Yeah, if you go age 25. The height, that's for younger people. That's for younger people.
It wasn't legal. I mean, there was no registration.
I thought that was fine.
That's what they
But
wanted.
that's what, I might be one of the two.
So I.
Is the diversion program the number?
Yeah.
And the height of this height?
Right, that's what age.
That's what it's an age, what's the age for the height? 23.
I'm not sure.
I know it's early, it's about 20.
I know it's in the 20s. I don't know what the exact age it is.
Yeah. Not way too.
So.
All right.
Deal with it.
didn't know nothing about this.
I know.
This was
They don't believe it or not, a lot of people have. They were. Yeah. Yeah. Shut down. Others, yeah. That's right. Yeah. He's just doing that kind of. I got a guy. Yeah, so it's a. So what case? Oh, okay. He's got no prior. So what do you like? He got six, like they got. He's pretty good at this. So I can. Understand the letters. Where is it? Where's the case at? It's set for exam. Where? Can't remember. Down here? Yeah, here, please. I would go to.
Yes, Kitty, this is the best one. The other one's good though.
The one from yesterday?
Mm-hmm.
This is pineapple mango again?
Remember Paulson? Oh, yeah. She's in Paulson. Oh, she's Paulson. He did again the last time.
Better than Cal was money.
So Cal bought the art. Yeah, I know that. Yeah, I know that. And then Paul retired again.
Yeah, I keep forgetting the door.
Oh, he never had retired. Oh, okay, so now Paul's retired. Yes. Oh, okay.
How much you say it was for the week?
35.
Do you know how much they each are?
$7.
No, what I meant was.
I said I might just do 3 of these.
Right. And, yeah.
Well, it's only 2 days left this week.
Okay, that's.
Then I'm off Monday.
So if you tell them now, you can start for next week. I'll do them on Friday.
So when it came up, I just, I get back. Yeah.
Oh, okay.
You see what I'm saying? So you tell them in advance.
So I can tell them 4 days,
You
well,
tell them the day, so when you come back Tuesday, you have.
So I thought that was, then.
I don't care what time of day I come in this store. Y'all just never working.
where you at, next door? Guess what? Is the jersey on the record?
I don't know, I walked up, made a phone call.
Oh,
Maybe he's not, because he's probably done all his probable causes.
trying to get these smoothies.
Right, y'all ain't doing nothing else, man.
Can you hand me that?
Right now.
What you want? Oh.
I ain't worried about nothing.
Thank you.
You're
Oh,
welcome.
I'm sorry. I mean, not sorry, but I apologize.
Come on in here, Tyrone, I'm doing your job. Here you go.
Thank you.
Well, as Tyrone would say, here you go. And the band played.
Yeah, check this out. SOS. There. You go
Yeah.
He's, because I hear you say that he's off, they're not doing things. What were you thinking?
For when? For next week? I don't know. She said he might not be able to do it tomorrow.
Oh,
She
really?
said maybe next
Be that
week.
too.
Let me ask.
I'm gonna get this, I want the
I got my
mango.
Why, were you in the car next to me?
Yeah, saw you down there blowing at you.
You saw me down there?
He was like, I don't look.
Yeah, it was.
Yeah, he said, I ain't
got
looking.
it.
I ain't looking.
I got it, man. Night, I got it tonight. Yeah, that's all right. Well, I couldn't get my arm much more up than this. It was my shoulder that was so bad for like 2.5 days, almost 3 days. And then, I mean, the day after I was here in the morning.
What'd he say?
My badge, I
Felt a
couldn't get in there.
little warm, and a little, foggy, tired, kind of thing, that was it.
Because the night was like a Wednesday, wasn't
I didn't have my
No,
badge.
I got it on the
What you got on there?
Hmm?
You got Tuesday, I got it on the
Yeah,
8th.
$10. I mean, $20.
Yeah, I got it on the 8th, and
Won
I was here on
$100.
Tuesday.
Oh, 50.
Yeah. Some of these younger APAs.
Oh, which one you see that one? I got $10?
Yeah.
Yeah, because they're.
Okay, I'm gonna try it.
Like this one here. Get a shot. I'm gonna take 2 days off.
I got mine on Friday.
Did you take 2 days off?
Oh, you know, it's in production. It's like, where's my badge?
Oh, so you got $20, right, $10 times two.
Oh, you will.
And you put
Yeah.
100 too, I got mine from 100.
Yeah, I want 100 off of a $5 ticket too.
sweet. I wasn't gonna be off without $100, but I won $100 or $10. I would have bought two.
Yeah.
I kept it for a while. I just started using it.
I'm going next year.
See, I'm scared to go to $20 yet. Have you did that?
Yeah, I have. This is,
You haven't been lucky on that one yet?
I did a long, long time ago.
I'm scared. I'm just like, if I get some enough money, if I get a stimulus, I'm gonna buy.
Yeah. And a pickup basket, if I come in the room.
No, I know. Usually, did you knock on the door?
Yeah.
You went through the one door?
Yep.
And you got the orange? How the times?
No, Larry, I sat in the hallway.
Huh? You sat in the hallway?
Yeah, I sat in the hallway and I screamed.
Did anybody hear you?
No, no one cared.
Okay. People there, you can't get broken. See, you won't still stop. Nice. Yeah, I know they would. Yeah.
Aren't you afraid you're gonna get
This is the only pair of shoes I have that I can still wear. It's a woman. Oh, I'm just.
Yeah, but I mean like with the protection stuff.
You don't see, you don't see, you don't hear about my feet so much, I don't know my feet are. I can't get a certain shoe, it's bad, what's bad? But.
Yeah,
come on. You can wear dress shoes and.
I mean, I wear
Dress
these
shoes.
glasses. Yeah.
Did you dance in those?
She ready for the,
Soft shoe.
she ready for the. Is it St. Patrick's Day today?
Yes.
I didn't even know that until someone was like top of the morning. I was like, oh, that's kind of funny. And then someone's like, happy St. Patrick's Day.
Well, I'm gonna work on a holiday. You usually drinking on this day.
I've never really celebrated St. Patrick's Day. I'm like really Irish too.
You know, it's funny, is that I work for the company.
Okay, yeah.
Yeah, all of us go.
Yeah,
Really?
You know, we got Michigan at the.
That's nice.
Which bar was, there's an Irish bar there, pub, and man. Well, there was a lot of them, turned out the lead officer. Oh,
Yeah.
Where'd you go? Someplace. Right.
You went upstairs and held your beer glass on the long table up there?
But one thing about it, I went, I got weed out of here.
Everybody does.
Right?
Everybody does.
Yeah.
Rocha. Okay. Usually like CVS or.
Rocha.
I think it's CVS.
Take a look at this.
Yeah. Yours looks thin. Like oh, it's not, it's thin. You got a piece of hair. Whose is this, huh? Where have you been? Huh? Whose is this?
How did you get good on me like this? That's how
good I am.
How's it going over there?
Good, it's pretty, nothing's really
Oh,
gonna start to wave the germs, it's pretty quiet for me.
Okay, go, okay.
I don't mind.
That's good. You have to have good days like that. I don't think you should see that. I'm sorry, you got that one.
So, no, you gotta set it up for the week.
Okay, did you pay for yours next week?
He told me to wait until tomorrow. He said he's gonna bring me one of taste. He said he's gonna give me one of his that he ordered so I can taste it and see if I like it. I'm like, I'm sure I like it. She over here bragging. Bragging about it.
If it doesn't taste good, we won't have to give it.
But he said just taste it, and if you like it, then I can set up the order for
Okay. Yeah, I'll just bring a little cup and share it.
Yeah, that's cool.
What is it?
I literally everything. I like everything.
Yeah. Some crazy stuff. I mean, I love how you come up with some real like using vocals that sound like some that sounds like some stuff, you know, just to me, I think it's all. I mean, those are deep. You can't sing. Right. That's this case. This case is wrong, all answers.
Yeah.
Oh, yeah.
Yeah.
Oh, okay. Oh, he can move here. So they can move your shade.
Yeah, you take it up there with you.
Okay.
Okay, I'll let them know.
Great.
Thanks.
All right, thank you. Let's just stay right here. What's your, let's take off. Hello, Your Honor. How you doing? Good seeing you.
Oh, you about to testify?
Yes.
Okay, come down here though. Don't, I don't want you behind you. Thank you.
Let's be quick. Oh, I'm sorry.
That's okay.
Are we ready? Is Moody here?
Yes, yes.
Oh. Ready on Kenneth Williams? Calling case number 2058179, the people of the state of Michigan versus Kenneth Williams. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination.
Your Honor, John Goldbluth, E30758 on behalf of Mr. Williams, what we are ready to proceed.
Williams, state your name for the record, sir?
Jim Williams.
Thank you, sir.
Oh, Judge, would you order sequestration?
No objection.
All right, you know, witness testifying today at trial and future hearing will be the court will be denied that future testimony.
For program, Uriel arrived, we would have to be accepted. Don't know if he's here. CDOIC.
Oh, no objection.
Okay, do the OIC an exception, should she show up?
Thank you. Calling Officer Rocha.
Where are our firms? So please don't shoot them, nothing but the truth, stuff like that. Hey. So the George George, you have a seat, please?
Okay, thank you. Good morning, sir. Your name for the record.
Officer Nicholas Rocha.
And Officer Rocha, I'm gonna take you back to the June 26, 2020. At about 1 p.m. or so, in the area of Nashville, 12,000 block, 12057 Nashville, Detroit. The on-duty officer at that daytime location.
Yes, fully marked car full uniform.
Okay. Who are you with?
PO Aline and PO Ayala.
Okay. Now, you were in that area for one reason.
We're on proactive patrolling the area in the 9th precinct.
Okay. Now, is that a city truck, by the way?
Yeah.
All right, there's something happened that brings you to the court today.
Yes, I observed, the defendant have a L-shaped bulge in the front of the pocket consisting of firearm.
Okay, for the record, they, just ask, you indicated consent. Is that person who you're speaking about?
Stipulate for the purpose of examining crime.
All right. Is that a
Stipulate for the purpose of
Oh,
examining.
okay.
Identification.
Yes,
Thank you.
yes, for just the identification, or not the rest of it.
Right.
All right. So that made Mr. Kenneth Williams, right?
Correct.
All right. Now, what happened at that date and time?
We were driving our scout car on the road and I observed Mr. Kenneth Williams standing in the street, interfering with vehicular traffic. I observed a L-shaped bulge in the front of the pocket consisting of firearm.
Okay, all right. Now, he's standing in the street.
Yes.
Anybody else around him?
I don't recall.
How close were you to him when you indicated that you saw an L-shaped bulge in the street pocket?
I don't recall how close I was to Mr. Williams.
All right, was it, this being 1 o'clock in the afternoon daylight?
Correct.
All right. Do you recall anything that was obstructing your view?
I don't recall.
All right. So you indicate a hoodie pocket. Whereabouts on Mr. Williams' person is a hoodie pocket?
The front of the stomach in the appendix area by the belly button.
Okay. So when you see him with that L shape, is it an impression or what, how did you indicate that?
It's a clear, it's a pretty tight imprint where the weight on the slide of the firearm was hanging down on the bottom of the hoodie pocket. You can see the L, you can see the handle come upwards, making the L shape.
Okay. All right. And was any part of this described item protruding through or outside the area? All right. So when you see this gentleman with that, pocket, what happens?
I exited the scout car, continued the investigation for interfering with vehicular traffic and see what's standing in the street while sidewalk provided.
Okay. Hang on just a moment. Where exactly was he standing?
I don't recall. I remember it was in the street.
It was in the street?
Right.
Okay. And now when you exit the squad car, you indicated you were further investigating. What did you do?
I exited the scout car and asked Mr. Williams if he had a CPO.
And why'd you ask?
Because he was concealing a firearm.
Well, from what you indicated in court here today, is that what you're relying on as far as the firearm?
Yes.
Okay. And when you approached him, when he asked him a question, did he indicate you could react to it all?
I don't recall.
Did he say, right there, did he say anything else?
I don't recall if he said anything else. I don't recall if he stated to us he didn't have a
Your Honor,
CPO.
can we go to a question and answer, please? Can we get to a question and answer?
All right, so what happens now?
We determined the fact that Mr. Williams did
What
not have.
objection did you do? What did you do, sir?
Oh, I determined the fact that, Mr. Williams did not have a CPO. I placed Mr. Williams in handcuffs and I conveyed him to the DDC.
Okay. Was anything recovered at all from him?
Yes, it was a Ruger handgun.
All right. When was this recovered?
It was on
At
the
what
same,
point when you were investigating was this recovered?
it was recovered when we were, when I was talking to, Mr. Williams.
Okay. So following recovering this weapon, what exactly then did you do?
I made the weapon safe. I, cleared the chamber, which did not have any live rounds inside, and I cleared the magazine from the weapon, which did have 2 live rounds inside.
Okay. Did you recover that weapon?
Yes.
All right. And what happened then?
I conveyed Mr. Williams to the DDC. And then the firearm went on evidence at the 11th precinct.
Did, with regards to this matter, was there any citation issue?
Yes, a citation for interfering with vehicular traffic.
You indicated that you placed this on evidence? The gun there?
The gun, yes.
Thank you. No further questions at this time, Judge. Carl?
Officer Rocha.
Yes, sir.
My name is John Goldflower. I'm going to ask you a few questions. If you don't understand the questions, say I don't understand them. Don't guess it's unexpected. Okay. Now, Officer Rocha, you indicated that you had some partners on that day, correct?
Correct.
Were you the driver of the car or were you not?
I don't recall.
You don't recall? Would it be a fair statement then that you don't recall where in the vehicle you were sitting during that while you were on patrol? Is that correct?
Correct.
Could have been in the front seat, could have been in the front passenger seat, could have been the driver, could have been in the back of the car, correct? Correct. Now, you also indicated, sir, that, well, were you on patrol when you made these observations?
Correct.
And where were you on patrol?
Around the area of Nashville and Bradford.
Okay, and that's in the 11th precinct, correct?
That's in the 9th.
Oh, 9th precinct. Okay, you said you put the evidence on the 11th precinct. Where are you assigned, sir?
Right now, I'm assigned at the 9th precinct.
Okay, at the time of this incident, where were you assigned?
I was assigned out to the technical service section.
Okay, so you and Officer, I'm sorry, your partners were Aline and Ayala. And you were assigned out to the tactical services, and so you don't have any specific assignments, but rather you're out there looking for guns and drugs and things like that, correct?
Correct.
And would that be the fair statement, that's the majority of your work?
Judge, I want to object to the relevance.
I'll withdraw the question. And there comes a point in time where you'll make an observation. According to you, it's in bright daylight, correct?
Right.
You told the prosecutor it was at
Yep.
1 o'clock in the afternoon, is that correct?
Correct.
And you had a clear vision of everything you said, correct?
Correct.
Now, when you saw this, made this observation, you don't recall how far away you were, do you?
I do not.
But it was, which was it on Nashville or was it on Princeton? Well, you indicate you're in the area of Princeton and Nashville, Bradford, right?
Yeah.
Right.
I don't recall which street it was on.
Okay, but the arrest was made where?
In the area of Nashville and Bradford. I'm not
Okay.
exactly
Was it
sure.
made on Bradfield or was it made on Nashville?
I'm not exactly sure.
Well, you indicated, sir, that you observed some actions by the defendant, correct?
Correct.
You went and arrested the defendant, correct?
Correct.
It was on one of those streets, is that correct?
Correct.
Now, and you don't recall where you were when you first observed him, do you?
In the car. Or
No,
the
where
sheriff.
you were when on either Nashville or on Princeton.
Correct.
Are you familiar with that area? Are you familiar with that area?
Yes.
Okay, and isn't it true that Nashville and Princeton intersect, correct?
Correct.
So if you were on Nashville, you couldn't see the defendant, could you? When you first made your observation.
Judge, I want to object. It's a form of the question and also speculation at this point. I think that he's already testified to that.
Yeah. I mean, I'm having a problem with the question too. I mean,
I'll
because
try mine.
it assumes, at this point, the facts and evidence are that he was at a certain location, he made this observation. If you're talking about at the location where he made the observation, you're talking about some other location.
He indicated, Your Honor, that while on patrol, he observed my client
And in the street.
impeding traffic.
Right.
They approached, And I'm asking, where did he see him impeding traffic? Do you recall where you were when you observed him impeding traffic?
We were on the street in the area of Nashville and Redford.
My question is, were you on Nashville or were you on Redford?
I don't recall which intersection.
And did you observe, when you made these observations, observing any other traffic going up and down whatever street you observed?
I don't recall.
All that, okay? And you indicated that you are familiar with the area, correct?
Correct.
Are you familiar that Bradford is a dead end?
Right.
Okay. But you don't recall any traffic going past Mr. Wiggins, correct?
Other than us, no.
And this was bright, sunshiny, and there were no observations, there was nothing to block your vision, is that correct?
I don't recall.
You testified that it was 1 o'clock in the afternoon, and on direct testimony, you said there was nothing blocking your vision, and it was bright, and it was clear. Do you recall that testimony now?
For being clear, yes, I don't recall if there was any cars that may have or may not have passed the block.
Of that I understand.
If that, yeah.
Okay. But there was nothing to deal with your observations or anything that you saw, correct?
Correct.
It was bright, correct? Okay. Did you make a report in this matter?
Yes.
Okay. And did you indicate in your report that this incident, you were on patrol, it was 1 o'clock in the morning?
No.
You didn't make that?
No, you already asked the question.
Well, I'm going to show him this report, Your Honor.
Yeah. Yeah.
Did you review that yourself?
Okay. Yes.
Reports are accurate, right?
Yes.
Tell in your report that you're on patrol at 1:05 hours, 1 o'clock in the morning?
Yes.
Well, you just testified that it was 1 o'clock in the afternoon and it was clear and was bright and you could see that nothing was bothering you with your observations. Is that correct?
Right. On that report, it said 1 o'clock.
That's right. Is this the report that you made, correct?
That one, no.
Okay. Who made this report?
I believe the first name was Ayala.
Okay, so this was one of your partners?
Yes.
Okay. So you're saying that this incident occurred at 1 o'clock in the afternoon, not 1 o'clock in the morning. Is that correct?
Judge, I got an objection line of question. He's not even showing him the correct report at this point in time. He indicated he was going to show his report.
Fine, Your Honor, I'll take his report up.
All right. All right.
Joseph, prosecutor first.
Right?
Joseph, prosecutor first.
Okay.
Okay. Did you have a chance to review that report?
Yes.
Is that your report?
Yes.
Okay. Did you, in your report, write down what time this incident occurred?
Yes, on the timestamp on the top, it has 01 or 2 hours.
All right. So it was at 1 o'clock in the morning, correct?
Correct.
Right. But you testified it was 1 o'clock in the afternoon?
I did.
Right. So it was wrong, correct?
So it was wrong.
Would it be a fair statement, officer, that you have no recollection of what occurred on that particular day, other than what your reports say?
It'll be fair.
What? I'm here to answer.
You said it would be fair,
It would be fair.
that he doesn't recall anything about that.
You don't recall anything about this incident?
But anything about the winter?
The incident?
The incident.
Other than my report.
I don't know what that means.
I don't either. I asked him, did he recall anything about this incident? And he said no.
Okay, you call working on June 26th
Yes,
and at 1 o'clock in the morning?
yes,
You call being in the area of 12057 Nashville?
yes,
Do you recall contact with this defendant?
yes, I
Do you recall with him, not just contact with someone, with him?
yes, with them, yes.
Right, and when you had you testified that you saw a L-shaped object in his hoodie pocket, front hoodie pocket, right?
That is correct.
You recall that?
Yes,
Without any support or report, correct?
correct.
All right, go ahead.
Well, can I ask you a question, officer?
Yes,
Why did you tell this court that this incident occurred at 1 o'clock in the afternoon?
when I read my report,
I'm sorry, when you read your report, when?
approximately half hour ago.
Oh, so you read your report prior to coming in here?
Correct.
Okay, that's fine. And you read that report. So other than that report and what it says, today, if that report said something different, you wouldn't know what occurred that day. Is that correct?
Well, if it said something different, it wouldn't be what occurred that day.
That's what I'm saying. So whatever that report says is the only thing that you know, according to what you said, you testified to.
Correct.
Yet, you didn't answer my question about why you told this court, after reviewing your report, that this incident happened at 1 o'clock in the afternoon when it was bright and sunny and nothing was up, was blocking your observation. Is that correct?
Correct.
So that wasn't true, was it?
Correct. I read the time wrong on the top.
That was my question.
Right.
You testified not to what was in this report, but that it was clear and sunny and nothing was blocking your observations. Is that correct?
Correct.
And that wasn't true, was it?
Correct.
So then why did you tell this court something that wasn't true?
I couldn't recall. I thought it was
You did not say, sir. I apologize, Your Honor. I apologize. I apologize. Go ahead.
I didn't recall if it was day or nighttime, and then when I reflected on my report, I read the time wrong on the top timestamp. I read it as 1:42 p.m. to 8.
I understand that, sir. That's, my question was, you didn't tell the prosecutor that you didn't recall if it was day or night, did you?
No, I didn't.
Thank you. You led this court to believe that everything was clear and bright and sunny and you had a clear view. Isn't that correct?
Correct, I said that, yes.
It had nothing to do with refreshing your memory, did it? When you testified in direct testimony.
Basically, you know, I guess gone over part of the question is also relevant to this point. What did it testify to?
Yeah, no, that was going into it. It's cross-examination.
So you're just basically, you're just gonna tell the court anything that you believe, here's my question, that, well, what you want to tell them, correct? Without saying, I don't remember something, correct? I'll withdraw that question. Now let's go back to when you first saw the weapon, or the alleged weapon, okay? Do you recall, were you in the car when you saw it?
I don't recall.
Well, did you testify on direct testimony your statement. You stated that you show his report again. Make this refresh his memory.
Well, he just said he needed to refresh his memory. You gotta ask him the question first.
Okay. Officer Rocha,
Yes,
did you state, all right, you do not recall where you were when you first observed Mr. Williams, is that correct?
correct. I don't remember my position in the car.
Okay. You don't recall where the car was either, do you?
Correct.
Did you state that you were continuing westbound on Nashville when you observed the arrestee standing, interfering with traffic?
Judge, I'm gonna object. I don't know if that's in fact in evidence at this point in time. I do know, though, that defense counsel is reading directly off of this report.
I am, Your Honor.
Well, I mean, he's entitled to impeach you. I mean, the officer kind of all over the place with it. First he testified he's in the car, and he testified he didn't know if he was in the car when he observed this. I don't know. So, he's entitled. Go ahead.
Do you understand my question?
Could I repeat the report?
Does that refresh your memory, sir, as to where you were when you observed where, and you know you're in the vehicle,
Right.
when you first observed Mr. Williams impeding traffic?
I was in the scout car.
My question, sir, and I understand, where was the scout car?
Oh. Westbound on Nashville.
Westbound on Nashville. And you then saw Mr. Williams standing on Nashville impeding traffic?
I don't recall if it was Nashville or Bedford.
So would it be a fair statement, sir? No. Now, were you in the vehicle when you observed this L-shaped form in Mr. Williams' hip or pocket or wherever you were?
Yes.
You were? Okay. And that vehicle was still proceeding westbound on Nashville, correct?
Correct.
But you do not. How far away from you, while you're on Nashville, did you observe this impeding and this object?
I don't recall how far I was from Mr. Williams.
Okay. You are aware that Nashville and Bradford intersect, is that correct?
Correct.
And this arrest and the observations let me ask you a question. By referring to your report, do you have an address on where you had contact with Mr. Williams?
Hey, wait, no. Take it back, please.
I'm sorry. Do you know the address in which you made your arrest of Mr. Bradley?
No,
Showing in the report?
Does your report refresh your recollection?
yes.
Does that refresh your memory?
Yes,
And what was the address?
I don't have an address.
You don't have an address. So it doesn't refresh your memory as to the address. You don't know what the address was. Is that correct?
Correct.
Was the arrest and your eventual detention of Mr. Williams on Nashville, or was it on Grayson?
I don't recall.
May I present his report, Your Honor?
If the report will refresh your recollection, in the report. The address wasn't in the report.
It wasn't. I agree. This is before you prepare.
I know, but then you no sense in showing it, it's not gonna refresh. He doesn't know.
Do you recall from the time when you were on Nashville, according to your testimony, that you observed Mr. Williams with this bulge if the vehicle that you were riding in made any turns?
I don't recall.
Do you recall at the time of the arrest and the detention, you got out of the car, right?
Correct.
And I believe you testified, correct me if I'm wrong, that you observed this bulge while on Nashville driving in the car, correct?
Correct, westbound on Nashville.
Right. Eventually, you get out of the car, is that correct?
Correct.
Did you then see the bulge again?
I did, yes.
And there was some bulge that you believed was a weapon, correct?
Correct.
It wasn't sticking out, it wasn't doing anything out of the ordinary, is that correct?
Aside from the imprint.
Imprint, correct. So that was it, correct?
Correct.
And When you exited the scout car, do you recall if you exited from the rear seat or front seat?
I don't recall.
At that point in time, that you asked Mr. Williams some questions, correct?
Correct.
It's my understanding that you asked him, according to your testimony, if he had a CPL. Correct?
Correct.
Did you ask him anything else before that?
I don't recall.
He indicated that he did not have a CPL, correct?
Correct.
You hadn't removed any weapons from him or anything of that nature, had you?
At that time,
When you asked the question. Did you actually remove the weapon that you put on evidence from Mr. Williams?
Yes.
Did you do that before or after he asked any questions? You asked him any questions?
I don't recall.
And would it be a fair statement that by showing you your report, that would not refresh your memory?
Right.
Let me ask you a question. Are you sure? I'm sorry. You indicated, I believe, that there was some sort of a bulge on his stomach.
Right.
And that's what drew your attention to it, correct?
Correct.
Did it give the impression to you that the weapon was in a front waistband?
I don't recall.
Okay. But you testified on direct testimony that it was
a hoodie pocket.
No, you testified, and we can read it back, that there was a bulge in the front of his stomach.
Yes.
That's what you testified to on direct testimony.
Yes.
Correct? And that's the first time you observed that weapon, correct?
Correct.
When you removed the weapon, where did you remove it from?
The hoodie pocket.
Okay. So it wasn't in the same spot where you first made the observations. Is that correct?
No, that's not correct. The hoodie pocket on the front of the stomach.
Anything else? Just one question, and I apologize. I'm just looking for something that might be able to refresh his memory as to where the service actually. That's all. No other questions, Sean?
Anything else, Brad?
Sure.
Yeah, give me the message.
Sir, can you tell us if you can recall, this happened at nighttime? The lighting situation, illumination situation.
When I refreshed my memory of my report and it had the 0100 hours, that refreshed my memory according to the report.
No,
Or
that
I
was
don't
the
know the
question
lighting
was asked.
situation. If it was artificial light or darkness.
Okay, you don't know. Can you tell the court, indicating that your report indicated the time on it, that your old call went through this with you, with what's stamped on your report? Can you tell the court what this means, the time reported?
Yes, what's stamped on the report is, military time. So 01, I believe it's 0147. On my report would be the timestamp
And this would indicate timestamp of what?
of when the incident had occurred,
When the
of
incident
when
occurred?
we generated our report number.
Okay, so if there's a different time on his report, i.e. two different times, can you reflect on the court what that might mean?
Yeah. If there's two different times,
Yes.
that could mean that,
Yeah, this goes for speculation, it's speculating, I don't know, I don't care what it could mean.
Do you recall the two times that you were on your report?
I do not.
They were, approached it, you can see your report in fresh recollection.
Yeah.
That's your report?
Yes.
Do you see two times, stand two times reflected on the report?
Yes, I do.
You see them? You see what that is?
Yes.
Can you tell the court what that is?
Yes, that's, like I said, when we generated the report number,
Yes, sir.
the 0109 is when we request dispatch for a report number that we have a incident or an arrestee or have to create a report.
Okay, so then the later time, the 142 or 47.
Yes, that's when I timestamped my report at the later date after the conveyance.
Okay. All right, very good. Can I approach it?
No.
Yes. Thank you. So to be clear, you saw an imprint on the defendant's hoodie pocket, which is indicated in the front.
Yes.
Of this person.
Yes.
You saw this from, where were you when you first saw it? In the vehicle or not in the vehicle?
In the vehicle.
All right. And you then approached it?
Yes.
All right. And
You
you got it, okay, nothing further.
Thank you.
You go over this.
Yeah, we will do, this individual. No.
I don't want to wait too long for me. Well, you got, you haven't made a motion, do you have any witnesses?
Oh, no witness.
Don't make a motion.
Thank you, Your Honor. I understand it's probable cause here.
Hold on, no.
Oh, I'm sorry, I thought he did.
All right. How do we make our most, the line go? As to count one, the court heard the gist basically of what this case was. The officer had some memory issues with it. Of course, this happened back in June of 2020. We know where we are now, about 9 months later. He was clear as to the area he was, who he saw with a L-shaped imprint in a hoodie pocket on the front part of his body, stomach area. He did then see that from the vehicle, he further investigated, went out, saw that, and that gave him the reasonable suspicion that there was a weapon there, and he did recover that weapon. And the testimony indicated that this gentleman did not have CPL on him. Furthermore, he was standing in the street area. Public area.
Your Honor, if that were all, we would be holding this. And I say that. Your Honor, it wasn't just I don't recall. Rather than, and I understand it's going to work, but he didn't just say, I don't recall what time it was. Mr. Moody asked him a specific question, and he said, yes, it was at 1 p.m. in the afternoon. That had been the end of it. Then all well and good, when shown something that would refresh his memory. He then went on to testify that it was bright, it was clear, there was nothing blocking his observations. However, he never recalled where he was in the vehicle, in a moving vehicle. He never recalled how far away he made these first observations in bright sunshine on a clear day. And he never recalled if there was any other traffic in the area to which it would be impeding. I know, Your Honor, that that's just a question, but it's still, when it brings to the reason why these officers were out there, it doesn't show, and there's no credibility to his testimony. When he was called on it, he even said he read his reports today, and he made a mistake to his military. Your Honor, they do this all the time. Clearly, he exaggerated his testimony to the benefit of him. Credibility is an issue, and all issues for a king. Your Honor, I would suggest to the court that under these circumstances, people have failed to show by appropriate evidence that this man should be done.
Well, Judge, with regard to, we were this strong with some exaggeration. I think that's because of the title and the quality of this officer. Apparently, he did indicate on the record that it was just before. Nonetheless, though, the crux of the case, I think, is made as a question of factors, the other surrounding circumstances.
The court, having heard the testimony and argument, as follows. I think the word exaggeration is a nice way to put it. What having heard the testimony of Officer Wilson testified that on June 26, 2020, approximately 1:00 p.m. afternoon in the area 12057 Nashville City, Detroit, full uniform, scout car, self-patrol. He said it was in the daytime, it was bright, and there was nothing obstructing his view. That he observed the defendant standing in the street. He was in a large L-shaped object, L-shaped bulge coming from his front hoodie pocket. He then exited the scout car, asked if he had a CPL, no CPL. Handgun was recovered, cleared the chamber, no rounds, 2 rounds in the magazine. He was also given a citation for interfering with illegal traffic. You know, the problem is his testimony, and it does affect his credibility, was a little bit everywhere. He didn't testify that he couldn't remember when this happened. He testified it happened in the daytime. It was bright and clear. When it was pointed out to him, what his report said, he didn't change his testimony. He said, no, it was at night. He testified he was in the car when he saw this bulge. He also testified he doesn't recall if he was in the car or not. He doesn't remember where the car was when he saw the bulge. He doesn't remember where he was in the car, if he was in the car when he saw the bulge. And he doesn't remember where the arrest was actually made. And it does go to credibility, but for the court to dismiss at a probable cause hearing, the issues as to the elements, I mean, he testified to, and he was unrelenting as to those, as to direct element. As to the other facts, that were connected to this incident, I mean, about being in the daytime and the light, that's, you call it exaggeration, and that, and I think that's being very nice. And some of the other stuff, you know, he just, I think was trying to support his action. But it's not enough because of the testimony as to the element for me to dismiss it at this case. Now, whether or not I would dismiss it at trial, that's a whole nother story. But that's not my obligation at this point. So at this point, the court's going to find that the felony complaint warrant in effect occurrence in Detroit probable cause exists to charge this defendant will be bound over to Wayne County Circuit Court Criminal Division for arraignment on the information, which will be March 31st.
Your Honor, the only reason I bring that, I don't put with the court's ruling. I just indicated that because under People versus King, this court could address credibility.
I said that.
I know.
I said that. The issues that the court found that, that this witness testified to that intensely or grossly affect his credibility didn't go directly to the elements.
That's interesting.
So that's why I'm letting it go.
And I appreciate that, Your Honor. I just was raising that point.
All right.
And Your Honor, on the 31st, do we know if this is actually going to be going on the AOI, or shall we just keep checking?
Yeah, you gotta deal with those folks over there. I have no idea what they're doing.
I understand, Your Honor. Thank you.
All right, thank you.
And Your Honor, off the record, good seeing you again.
Good seeing you too. We got Paul.
I know the attorney's out there. See, she went down to see if her client was in because she said something locked mine. Okay, Ms. Palmer. The attorney is like attorney for a nephew, so.
Yes,
that's why it kind of got me off for a second. You'll see.
He's not here, okay?
Well, I'm saying, yeah, I'm gonna go out there because she was here. She said it's on its way. That was a while back. This Ms. Palmer's client?
Yeah, they're here.
Okay, very good.
We still got time.
Farmer's not current now here.
Palmer is at 11:05.
Right.
She, I don't know where she goes.
Yeah. She went downstairs.
Well, I'm calling Kate.
Let me go.
Make the.
Right.
So.
Yeah.
Judge, look at this. This is on Monday. I'm not gonna be here, remember.
That's Monday?
This is Monday. It's 24 PCCs and I think 16 exams.
What day is that?
Monday.
Ms. Palmer.
You may call the case.
Know how they PCCs.
I'm gonna call Mr. Ray and get her. Call her. You can call her Kate.
We call
Palmer. You did. Palmer.
Calling case number 2058308, the people of the state of Michigan versus Hosea Palmer. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for examination. Defendant has failed to appear.
Before your Honor, question people. I do have a trooper Raps here. RAAP for the report.
Good morning, Ronald.
Palmer Bryant, 63927, we have for Bear Palmer. He is not present in my presence. I did have an opportunity to go to the downstairs, he's not in the line, but I did speak with the trooper who also saw him in the vicinity as they were parking, so I'm not sure where he is, but he's not answering his phone.
Well, he's not here. So KP shall enter. Any bond previously submitted shall be forfeited. Any bond status 30,000 cash. Thank you.
Five. 52607.
Hi, Patrice, this is Judge Giles, and
No, and that's why I something like. So I would have to,
Yeah, she was trying to save you.
we get taken care of, so that's not my guess.
Are you,
I'm on forward.
Yeah.
okay.
Yeah, he said probably 3 hours.
Really? Call me.
Yep, that's my work cell, that's my personal cell, and you can call me here. I don't answer. That's my work phone as well. So yeah, you probably leave that, I guess all that.
Right.
Got work tonight, so.
Oh, yeah, it's all you.
Yeah.
Yeah, take care now.
Take care.
Have
a good day.
See ya.
Yeah.
That's how some finest guy does. Papers.
Is our 11:30 here?
Don't know.
Ty? Is our 11:30 here?
They
Yeah,
are,
they're here.
there's no officer, no witness.
Not yet?
Yeah, I thought they should have 11:30.
All right. They can come in.
Kathy's talking to him right now.
Oh.
PCC.
I think it's 23 pieces.
23 PCC.
Yep.
Still next door?
Yeah.
Yes, they right. Something
Yeah, now, 22. Oh, my God.
22 on 22.
What they call the case, huh?
22 PCCs on 22.
On 22. What do you mean?
March 22nd is 22 PCCs.
Hey, 444, 2.
Oh, man, don't say that.
Or 322. That's a good number. 223.
Yeah.
Mm-hmm.
You said 233.
I said 223.
Oh.
322. It's the same thing if you switch it around. Third, 22 days. And you will let you know. 322.
And 16 exams. This is Monday that I won't be here.
That's right, you won't be here on Monday, right? Oh, I hope we get someone good, don't they do?
Yeah, they should.
You got Juanita, she floats, you got Carmen that floats, you got another young lady.
Now, Juanita, they have been put in Judge Bryant. She's been with Judge Bryant.
Really? Yeah, I think I heard of one.
I'll say, I'm in.
She had a good officer too.
Yeah. I know.
Yeah. You can tell what you want, they lost it, what you have. So this, what is this?
I love it.
What's he on the couch? You know what's so bad? That case that this was. I thought he was gonna go. Cause he.
I did too.
And they're like, damn. And this is and that's the great question. You said it was late. How can you see it late? How much light? Why? You know, how far from where you saw the march and it's dark. That could have been anything. You know what I'm saying? They said impeding traffic because that gave a chance to do something. How can you impede some traffic at 1 o'clock? Wow, what's the traffic at? What kind of traffic is it? There's also dead end street.
It ain't from the club, because they in the club.
That's what I've been. He kept talking to each other. Get to this. Direct. You should talk about that and go from there. Yeah. Mm-hmm. Okay. I think this, Silver, tore that up.
Oh, yeah. You didn't have right.
She was? Because I think Gary's way, just something.
Yeah.
Make him think about, saying, okay.
Harry went back. I was wondering.
Yeah, I think he might come. Yeah, he hurt himself on the ground.
grew up in LA. Where you at? I graduated from Fairfax. I went to John Burroughs.
I told him, I said, hey, that's my girl now.
Huh?
That's my girl now.
So married out.
You been gone, brother.
I was just joking, but I wanted to tell him, I wanted to mess with him, see how he reacts.
You should have said that.
Yeah, because you know he likes to be here talking. It's on my mind. That shit too.
I used to like him in here.
Yeah. But I'm better,
Michael Jackson. Oh, yeah.
My uncle's mom is married. Yeah.
My grandpa.
Oh,
I got them all. 93, 90.
yeah, the case we had was, we had the pre-exam, but she has the old case, so we sent our case to her, but she had the older case. But she said she didn't want to. Oh, okay.
This is 93.
Which one?
Right there. You know, that's me.
You ain't right.
This is my 92-year-old.
Larry, you ain't right.
And then this is my 85-year-old.
Oh, okay. So do you want me to tell the judge or?
Now, those older women live in California.
No.
Yeah. Yeah, so I'll let them know. I mean, congratulations. You know, y'all just moving all around down there. I was like, what? I see. All right, thank you, Ms. Jackson. All right.
Okay, guys, court's back in session. No, you stay right there.
Judge, Ms. Jackson called regarding that, the case we sent down. She said that she explained it to them why they need to have the plea.
Just in case.
Oh, we ready? Where is?
Yeah, he just stepped out, but we ready. He's right there. Could you have this?
Who stepped out?
Blair move.
Oh, and she said, Ms. Gray is out the building.
Yeah.
Oh, they told you that? Okay. Oh, did he say he's having the same problem?
Yeah, they scheduled 40 PCCs.
I don't know what they're doing. They're not spreading them out right. They're not looking and keeping track of what they already put out there. There's no way it should be like that. We ready?
Yes.
Everybody? Okay. Calling case number 1660799, the people of the state of Michigan versus Richard Barney. Defendant is charged with count 1, controlled substance, delivering, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, delivering, manufacturing marijuana. This matter is scheduled for examination.
Good morning, Your Honor. Prosecutor Boyd Williams, the people.
Morning, Judge. Neighborhood Defender Service by Gleno, PA 3424, hearing on behalf of Mr. Richard Barney, who's present in the courtroom. Mr. Barney, please state your name.
You ready to proceed?
Judge, at this time, the people are not able to go forward. We have our complaint witnesses here, the officer witnesses here. That's not before, as I indicated. For the record, we request signature.
Judge, we'd object to the adjournment and ask for dismissal.
All right, now it's dismissed without prejudice. Can you discuss the point, please?
Yes, Judge.
Thank you guys very much.
Clean the docs for this morning?
Oh, is it?
Yeah.
Yep, sure is.